like the Order Paper podcast, hit like, tap subscribe. And if you really want to back more content, drop a super thanks or become a member.
Yeah, so thank you for listening to me today. I'm an adjunct lecturer of animal law at the University of Otago, and I've been an animal law practitioner for a number of years, including as the former president of the New Zealand Animal Law Association. And like many others who have spoken on this bill, I'm very concerned by it, I oppose it, and I have 5 points I'd like to make. So firstly, this bill completely undermines a decision of the High Court and the purpose of the Animal Welfare Act, the country's leading piece of animal welfare legislation. So as we heard just before from Gillian Coombe KC, there was a 2020 decision by the High Court in which farrowing crates were found to be illegal, and this resulted in a phase-out period, which this bill now sidesteps. And I completely echo the comments made by Gillian Coombe in relation to the concerns around the rule of law in terms of a bill completely undermining that judgment. So secondly, the real problem with this piece of legislation is it deprives the 2015 amendment to the Animal Welfare Act of its main effect and purpose. So one of the main purposes of the Animal Welfare Act is to allow animals to express normal patterns of behaviour. And prior to 2015, there was a provision in the Act which allowed, in exceptional circumstances, practices to continue, which did not allow animals to express normal patterns of behaviour. And this was routinely used to justify certain practices like farrowing crates and battery cages, which actually do not meet the obligations of the Act. And that's why Parliament amended the Act in 2015, right, and inserted this new regime under Section 183A to require non-compliant practices to be clearly phased out with strict time limits. And this bill completely ignores those time limits. And I refer you in this regard to a couple of key comments from Justice Cullen, her High Court judgment, in which she said it was plain that Parliament's intention in passing this amendment was to ensure that non-compliant practices were to be time limited to up to 10 years only and ultimately phased out, and that any extension of time was to be limited to up to 5 years once only. I also refer you to her comment at paragraph 84 that farrowing crates were explicitly given as an example of a non-compliant practice in the explanatory note to the 2015 bill, which Section 183 sought to address. So this bill is effectively saying Section 183 applies except when we don't want it to, and that's very problematic. Thirdly, this bill continues beyond 2035 practices which I think by any reasonable interpretation are unnecessary within the meaning of the Animal Welfare Act. We all know that half of pig farmers already farm without the use of farrowing crates in New Zealand, and they're banned in a number of countries like Sweden, Switzerland, and Norway, which are clearly leading ahead of New Zealand, and which obviously raises some concerns for New Zealand's international reputation with respect to animal welfare as well. And I echo completely Gillian Coombe's concerns that NAWAC, which was the government's expert committee on animal welfare, has this view, and yet it's being ignored. Fourthly, this bill has been subject to significant procedural defects. It has not been subject to a proper consultation. Now, NAWAC consulted on 2 options in their draft pig code in 2022, free farrowing or temporary crating for up to 72 hours. And public consultations are a key principle under the Animal Welfare Act. They're required, and that is because there is enormous public interest in the treatment of animals in Aotearoa. And yet these proposals, as put forward in this bill, have not been properly consulted, and this rushed-through piece of legislation is not an adequate substitute for that. Fifthly, I'm pretty concerned by what I've seen in the news subsequent to filing my written submission, which has come out through Official Information Act request, which gives pretty strong indications of regulatory capture. Now, this is a piece of public interest legislation, the Animal Welfare Act. Its purpose is to uphold the public's belief in the humane treatment of animals, and Justice Cull, in her High Court decision, emphasised that practicality and economic impact are not the primary purpose of the legislation, and they cannot override the welfare obligations of the Act. But this bill seems to ignore that, and I am rather concerned by the influence that New Zealand Pork seems to have had on this legislation. It seems unduly large. It seems more significant than NAWAC's own impact, despite them being the key committee under the legislation for recommending animal welfare changes. So those are my main points, and I'm happy to take any questions.
Members, we have about a minute left to have questions. If Danielle would like to field any from my team, please speak up now, because we've got Danielle for about a minute. Danielle, there appear to be no questions. Thank you so much for your submission. We're very grateful for your submission. It's very succinct in your delivery. So I hope you have a great day, and thank you for your thought. Thank you for your thoughts and ideas.
Yes, thank you, Danielle, for that, because you're absolutely correct. New Zealand's pork industry is made up of about 70 to 80 commercial farms producing about 600,000 pigs. About 55% of these pigs are produced in indoor facilities. That means about 45% of pigs are actually outside already, right? On top of that, we import about 60% of our pork products. So I don't know why we're doing this legislation. Why are we doing this 10 years? Battery chickens are treated better than this.
Yeah,
right?
yeah.
And pigs are more intelligent.
Yeah, you're so right. Yeah, chickens are treated
So
better.
just give the pigs some damn straw and some more space, right?
Yeah.
you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok. Who's got the order, baby?